Welcome to Discovering the Law. My name is Lucy Rivera and I am the host of this program. This program can be viewed at www.discoveringthelaw.com. Today we have very special guests. We have Peter Durney, a partner at Cornell and Golub, and we have Chris Duggan, a partner at Smith Duggan. And they're here today to talk about the American Board of Trial Lawyers, or ABOTA. Welcome to our program, Chris.
Nice to be here.
And Peter, thank you very much. So please tell us, what is the American Board of Trial Lawyers?
Trial Advocates. ABOTA was founded in 1958 in California. It started and has since moved across the whole country. It was founded originally because there was an attack on the civil jury system. The notion was becoming more and more popular among certain circles that individuals, common citizens, were not smart enough to be jurors and decide disputes between parties. And the notion was by certain people that only some special arbitrator or some special judge should be deciding these cases. And ABOTA was founded to point out to citizens in general that civil jury systems have been with us since well before our country was founded, and it really was part of the core of being a citizen to sit on a jury and to decide disputes between people or corporations. It's enshrined in our 7th Amendment of the United States Constitution. And from a fairly humble beginning in California in 1958, we now have about we have over 7,000 lawyers nationwide.
Very interesting. And what is your mission? What's the mission of ABOTA?
Well, the mission, there are several missions. One is to preserve and promote the right to trial by jury in civil cases, which is still today under attack, and we see it in many things. For example, in medical malpractice cases, there are attacks on getting rid of juries in medical malpractice cases, in certain auto cases, and things like that. And we believe firmly that the right of all citizens to participate in juries is central to being a citizen of America. But also, we do a lot of educational work. We develop programs to educate young people, junior high school in law students, for example, as to what law is, what trials are, and how they're conducted, and why it's important that we have a jury system, and also why it's important that we have an independent judiciary. There are 3 branches of government, as you know: executive, the legislative, but the judicial is a 3rd branch, and we must have 3. We must have an independent 3rd branch. And so we have founded, one of our missions is to support and develop an independent 3rd branch.
Oh, very interesting. So does this apply to civil cases? And what is a civil case? And what's the difference between that and a criminal case?
Well, first let me say that Chris, he's humble enough that he won't say this himself, but Chris is the National Secretary for the national organization, but both of us serve as national board representatives for that group, ABOTA. But to answer your question, a civil case versus a criminal case, there are 2 main differences. A civil case is a dispute between citizens. It could be a corporation and a citizen, an individual like you or I. It could be 2 corporations. It could be 2 neighbors. A criminal case is different, of course. A criminal case usually involves a crime. Goes without saying, and it involves the government. It could be the state, could be the federal government, could be local. Our organization focuses for the most part on civil cases, but I think from a juror's perspective, and the people that are likely to watch this program may at one time or another be a juror if they haven't already. From a juror's perspective, there's a different burden of proof, and that's part of a movie that you'll see if you come in to serve as a juror in the Commonwealth of Massachusetts. It will explain that the burden of proof differs from a civil case to a criminal case. In a criminal case, you have what's referred to as beyond a reasonable doubt as the standard, and that's explained in detail. We don't have that standard in a civil case. What we have in a civil case is by a preponderance of the evidence, and sometimes that's represented by the scales of justice, and there are instructions that are given to the jury, the charge that you're familiar with, just before the jury deliberates, and the judge is likely to say something like this. The scales need to be tipped ever so slightly in favor of one party or the other. So it's not beyond a reasonable doubt, it's just tilting the scales, and once you meet that burden of proof, then you're entitled to a verdict in your favor, whoever the party is that carries the burden of proof.
And why is it important to have a jury, a civil jury, in this for a trial? Why is it important, a jury system?
Well, the general question of why a jury is important would take us a few days to explain. Chris has an awful lot of history behind that, and I'm sure he'll be happy to fill in behind me on this. But
well, in a civil matter, why is it important?
In a civil case, generally what you're doing is deciding a dispute that if you've never seen it before, if you've never been involved in a contract dispute before, if you've never been involved with a particular drug or a device before, still you can come in as a juror and you can bring your personal experience and you can bring your life worth of dealings with people, and you can decide the dispute just based upon the information that you have from your own background, but also what you hear presented in the course of the trial. And so it's really important from our perspective to have jurors that are fair-minded, but also jurors that want to be part of the process, because we're very excited about this process. And I think the jurors that we've come in contact with after trials or during mock trials, where we might carry on a mock trial, those jurors tell us time and time again that they really enjoy being part of it. But for our clients, we care about fairness. And the best way to get a fair result is to put 10 or 12 people in a box and have them collectively come to a decision. That's the way we view the jury system, the importance of the jury system.
Can I follow up on that for just a minute? Because I agree with what Pete just said in terms of the clients that I represent. And I tried principally cases for defendants, but I've also tried plaintiffs' cases as well. People who have been injured, for example, or people who have some complaint against another party. And I would far rather have 12 citizens sit and judge evidence than just one person, no matter how wise that judge might be. The collective wisdom of the whole community, which is what the jury is supposed to be, is something that is unique to America. We are one of the few countries in the world that have this, and we're so lucky that we do. Pete talked about history, so I'll go on a little bit about this just briefly. John Adams called the jury system the heart and lungs of liberty. And he was a trial lawyer. He tried cases, civil cases, before juries. He had such a love for and commitment to the notion that citizens could be called to decide disputes between people. Because what's the alternative? Back when Adams was trying cases before the Revolution, the alternative was trying it to a judge that was appointed by the king.
Well, is this how jury systems came about? Like, how did the jury system come about? Is that how, how it came about?
The jury system originally came about way back during the reign of Henry II in England in 1170 or thereabouts, when it was decided that it used to be to decide a dispute between two parties, whether it be a criminal or civil, because the lines were a little more blurred than 1,000 years ago. They would have either trial by ordeal, where someone would actually, they'd dunk you, and if you drowned without confessing that you were wrong, then you must have been right. Well, that obviously didn't seem to be the right answer. Or they would have trial by combat, jousting, for example. And Henry II decided that was probably not a good idea in a reasonable way, so he came up with the notion of putting 12 people, 12 landowners at that time in a box, and making a decision based upon what seemed reasonable. And then sending judges around all of his realm in England and what is now part of France. So that was 1170, and it has grown and has become part of the American system ever since. I mean, when the Puritans came to this country and landed in Plymouth, for example, one of the first things they did was pass the Body of Liberties, which here in Massachusetts Bay Colony at the time said that every party would have a right to a trial by jury if he or she wished. So we've had it here in Massachusetts since the 1640s, and it has been part of being an American citizen ever since then. So it's something that really is part of being a citizen.
And I interrupted you when you were talking about John Adams because I wasn't sure where you were going with that, but can you just continue that thought?
Well, it's really the same thing. Adams was very concerned because the Crown was taking away the right to trial by jury and putting more and more cases before court-appointed or king-appointed judges. And the problem with that is, of course, is that the king controls the judge, the king pays the judge, and so what's the judge going to do? More than likely, he's going to vote for whatever the king wants, right? And that's why why it's so important that we have juries. Jefferson said that the jury was the only system ever invented where a government could be held to its principles. And the reason for that is a judge alone is beholden to the president or the king who appoints him or her, whereas the jury is completely independent, and they make their decisions based only upon what the facts that they find them in the law as instructed. And it's a remarkable system.
Well, it's very interesting about the history, but what happens in really complex legal issues, trademark or complex litigation, where I don't know the issues on complex trademark or pharmaceuticals and legal intricacies. What would happen to someone who probably just had a high school and maybe is not familiar with the terms or the problems that are involved in the case?
And I would hope that those that are listening to this or might watch this would understand that we want those people on our juries, that we want them not to be intimidated by the system in any respect, because it's very important that they participate. And it's not just that it's their jury service or their civic duty to come, but they bring their experience. And you'd be surprised, some of the conversations we've had with jurors after cases have resolved, either they've settled or they've been tried, the jurors understand. You can have a ninth grade education, and you can understand English but not understand it completely, but do your best to understand. You can listen to evidence presented over two weeks' time without any distractions. No one's reading the newspaper. Nobody is calling you on your cell phone. So you're concentrating and you're listening to the presentation from the lawyers. Hopefully they'd be good presentations. Hopefully the interruptions are few. And hopefully the evidence is not so boring as to put you to sleep. That does happen from time to time. But at the end of that period of time, you have an understanding about something that you never had before and that you'll carry with you for the rest of your life. It's amazing. Whether it's an automobile, or whether it's a particular drug, or whether it's a medical device, or whether it's just a contract issue having to do with the purchase of a home and something you knew nothing about before. But I guarantee that after a week or so, or even a 2-day trial in a courtroom with no other distractions and paying attention to the evidence as it comes in, as long as the lawyers do their job, that anybody can serve as a juror, as long as you have the capacity to listen to the evidence and you're committed to it. And you're fair-minded going into it, so you don't have any bias.
Okay, and would you be rather, how would it be different if there were experts in that particular subject of a specific drug from a pharmaceutical company? And if you had them to be in the jury, wouldn't they be more apt to understand what's at stake or not?
Well, there's actually a couple of,
Sure.
There's a couple of responses to that. The first is, that sort of supposes that common people are not smart enough or not wise enough, not capable enough to understand the evidence that's presented to them by the lawyers. That simply isn't the case, as Pete was saying. It's up to the trial lawyers to put the evidence in a clear, concise manner and make the best arguments that they can on behalf of their clients. But juries have a remarkable ability, because there are 12 or 14 or 16 of them, or 6 if you're in the federal system, and they bring their experiences to bear and their common sense to bear to decide what is right, what is wrong, what is fact, what is fiction, what happened, what didn't happen. Now the next question is getting to the experts. The problem with deciding things or trying things next to experts is that they come most of the time with a predisposed bias, naturally. Their bias is what their education is, what their history is, what their experience is in a particular topic, which is fine. That does not exclude them from being jurors, but it does not make them the only juror or necessarily the best juror, because they may be so convinced before they hear the evidence as to what the outcome should be based upon their expertise that they don't hear the whole story behind the dispute.
And just one thing on follow-up, there's no prohibition against judges sitting on juries. There's no prohibition against lawyers sitting on juries. There's no prohibition against policemen sitting on juries or any other citizen sitting on a jury other than the few limitations that might exist, age, etc. And we often say in our closing arguments that when people took the oath of service and were sworn in as a juror, that nobody asked them to leave their common sense at the door. And so they bring to the proceeding everything that they brought with them up to that point in their lives. And that's really valuable, because when you put it all together, everybody has a different view, and then it's collectively what they decide. And 9 times out of 10, it's correct.
And the American Board of Trial Advocates, you mentioned that the organization promotes the 7th Amendment. So, and also when you talked to us about John Adams, was every single case entitled to a jury trial? The civil cases entitled to a jury trial?
Right. Well, not every case gets a jury trial, even today. But start with 2 things. One, the United States Constitution, which was drafted in 1787 and ratified in 1788, was actually based in large part upon a constitution that John Adams himself drafted 10 years before that, in 1780. And in the Declaration of Rights in Massachusetts, Article 15 says a right to trial by jury even in civil cases, not just criminal cases. So it was important enough to Adams to put it in right at the very beginning of the Massachusetts Constitution. There are certain cases where, based upon history or tradition, there is no right to trial by jury, even if both parties want it. Admiralty case might be one example, or a case in which you're looking for the judge to give specific relief that does not involve money damages. So if the judge is looking for, if you're looking for something to order the judge to, looking for an order for the judge that moves property from one party to another, that's called equitable relief. But other than those narrow areas, in almost every other civil case, the parties have a right to request a jury trial.
And now, talk to me, tell us a little bit about jury service, the way you call it, versus jury duty. Why are you making this distinction?
I like the term jury service rather than jury duty. When you hear about jury duty, you often hear people say, geez, I've got jury duty next week or next month, I want to get out of it. It makes it appear that it's some sort of burden. It is one of the few, serving on a jury is one of the few things that our country asks of our citizens, all of our citizens. And it is a service to themselves and a service to the whole community. And it really doesn't seem to be that much of a burden. But more importantly, when you look at it, in 1860, for example, the only people who could be jurors were white males. And in Worcester County, 2 black men were seated. Now, this is at a time when there were 4 million African Americans enslaved, and 2 blacks were seated on juries in Worcester County, and the impact that made on the whole country was dynamic. Why? Because it was a vestige of being a citizen. After the Civil War, women still could not be on juries. Not until 1870, of course it's outrageous, you say it's outrageous, not until 1870 the first woman sat as a juror. And women, as part of the suffrage movement, moved to get on juries. Why? Because it was part of being a citizen. You want to hear something that's really outrageous?
Yeah.
The right to vote for women came in with the 19th Amendment in 1920. The right to serve as a juror in Massachusetts, I'm embarrassed to tell you,
Oh, no.
not until 1950.
That's appalling.
Yeah.
It is.
But
terrible.
and women were rightly, and not only women, there were men who were rightly appalled by this. And why? Because being a juror was a vestige of being a citizen of a free country. And that's why I use the term jury service, not jury duty, because it's a service to all of us.
And how does the organization that you both so passionately represent and are very involved in, the American Board of Trial Advocates,
Yes.
ABOTA, what does ABOTA do to promote the health of the jury system? And
Well, I'd let Chris tell you a little bit more about some of the programs, but first I want to focus on one thing. You said the health of the jury system,
Yes.
and that's very important to us.
Okay.
That is why we are so passionate about this and why the organization is so passionate about it, because it was organized to preserve the jury system. When you think about the statistics, it's overwhelming. In 1984, there were approximately 60% more jury trials than there were by the year 2009. Less than, now, in this day and age, less than 1% of civil disputes are tried to a jury. 1%. Wow. That's amazing. It's dropped down from about 6% some 20 or 30 years ago.
Right.
And so fewer and fewer trials occur. And the reason for that is perplexing. But what's happening is people are being denied the opportunity to have what they're absolutely entitled to provided to them in the way of a jury trial. And to preserve that, ABOTA has various programs, and hopefully we have some time to talk about them now, but if we don't,
well,
on
we
some
have a
other
minute
occasion.
if you
A
want to
minute will
mention a
probably
few.
not to do it, not do it, but
Maybe don't go in
suffice
depth, but,
suffice it to say that ABOTA representatives throughout the country travel from jurisdiction to jurisdiction, promoting civility in the courtroom, backing judges that are under attack for various reasons, if they're unfairly attacked, and talking to communities, talking to lawyers, encouraging them to become actively involved in the civil jury system, to not give up hope that the jury system can survive, and including programs educating young people. Chris started the most amazing program, and you can witness it yourself. It's in the fall. It's called the James Otis Lecture Series. And he gathers together high school students from all over Massachusetts that have been designated as Otis Scholars, and they come to the State House. We've done it at Faneuil Hall, we've done it in the State House, and listen to lectures, 3 or 4 speakers on the history, and oftentimes it involves the history surrounding the legal community and its origination, and we have a very historic, rich area out here, but I think this is a testament to its success. It has caught fire throughout the country, and now it's in how many different places throughout the United States?
We have 11 so far.
11 different states have picked up on the James Otis Lecture Series and have promulgated it in one form or another in their jurisdictions. And the good news is that that's accolades to Chris. Bad news is he often is asked to travel, and he has to go from place to place because he's the superstar, having invented that. But that's one of the things that is done by the organization.
Well, I want to thank you both for this very interesting insight of the legal system and the jury system, and I think our viewers learned a lot today about how the legal system works and the judiciary and and the jury system. But we have actually no more time, and I want to thank all our viewers for spending some time with us and discovering the law. Today we had Chris Duggan and Peter Durney, and they are members of ABOTA, the American Board of Trial Advocates. And my name is Lucy Rivera. I thank you so much for your time, and this program can be viewed at www.discoveringthelaw.com. Thank you for watching.
Thank you for
having
us.
us.